Okay, we have Karawanski versus Karawanski, Kazarowski, excuse me.
Good afternoon, Your Honor.
Hello. This is a matter of getting a deed signed here, is that correct?
That's well,
Your client wants to get on this side and he can
we need to pay money to get a deed signed.
get $60,000.
Yes.
And you said the $60,000 was paid in your escrow
It's in
account.
my escrow account.
Was it later? What's your side of this?
It's a lot more than 60,000 at this point. Property values have increased. This agreement was made. There's a matter of my motorcycle that was destroyed. The guns that were supposedly stolen, my tools, about $30,000 in tools that were supposedly stolen. Child support that hasn't been paid for 4 years. I give her the company in lieu of not paying child support and alimony. I've had kids myself for 4 years. And a couple other things.
How late was the payment? 60.
Pretty late, Your Honor, but of course, there was never a default notice or never a specific.
Well, I'm gonna answer that.
I know that. Your Honor, you're supposed to have it paid in sometime in 21. And I want to say this, Mr. Kazarowski has always indicated to Ms. Kazarowski that time was not of the essence and such. So I don't want to be overly disagreeable with him. But yeah, it's a couple of years late.
Was this a total agreement that was signed as part of it, or what's?
Your Honor, I was not involved. It was Craig McLeod represented Ms. Kazarowski, and Mr. Kazarowski was pro se. There was a separation agreement signed, and there's a handwritten, if you look in the file, agreement, which they've gone by and was apparently incorporated in the decree. And it's a little hard to read. It's about 4 or 5 pages and 6 pages, I guess. But bottom line on
The
this,
child support.
anyway, there's no money. Your Honor, he's bringing stuff up today that is not worth for.
Yeah, that's always a problem when you don't have a lawyer. You would have been much better off to invest a few $1,000s and gotten a lawyer instead of trying to represent yourself and write this stuff up and not having enforcement sort of things. I don't know. I knew this was a mess when I read this motion when it hadn't been paid a year. And I think you can make a pretty good argument that being, 4 years late and making a payment, might materially change the agreement or alter the agreement. What I'm going to suggest is that you lawyer up, okay? And then I'm going to set a hearing date for this, and we're going to hear this thing from beginning to the end. It's not fair for your client for me to just throw out the $60,000 agreement. I'm not going to do that without hearing proof, and then we'll and these other things you brought up here, Mr. Cross makes a very good point. You just can't come up here. This is not like Judge Judy or let's make a deal where you bring things up. This is a court of record. And, you have to file appropriate pleadings, and you're held to the same standard as an attorney would be if you want to represent yourself. And so we're not going to do that. So I'm going to give you, 20 days to get an attorney and file a complete motion and set out what you think is to be determined, the findings and all that sort of stuff, and why the agreement that you have signed should not be enforceable. Mr. Cross will have 20 days from that to answer it, and then I'm going to schedule a hearing quickly on the whole thing. So we won't have to piecemeal. You can't piecemeal these things; they're interconnected. But I'm going to rule that the children stay where they are. And does she get visitation with the children?
Yes, I legally have full custody. They've been at his house for 2 years, part of which I also lived there. I moved to Washington and I moved back.
Did y'all reconcile in that 2 years, or did you just live there?
I had went to a rehabilitation center and moved in there afterwards.
When you moved back, were you living together as husband and wife, or were you just living together, basically? Were you intimate? I don't know. I don't have to draw a picture here. Okay, well, what you need to do is within 20 days, you need to have an attorney. And if you want any of these things protected, you need to give complete notice to this lady on what you agree, what you don't agree. And I'll try to, okay,
So I'll submit an order, Your Honor, 20 days for him to,
to completely
Counsel.
state why he thinks the agreement he signed should be set aside and any other issues that he has that he thinks are unresolved. He
then I
needs to
have
set
20
them
days
out
to
in-
respond.
You need to set them out in detail. I'm not gonna say, I signed a bad deal or I didn't do this. You're not gonna win on that argument. Okay, if there are things that aren't included and that sort of thing, but I don't know whether you've ever played any poker or not, but there's what's called chain betting, you know, where somebody will say, I bet $10 to see what the reaction is, somebody else, and then they take it to 30 if they think they can reboot. We're not gonna be doing any of that, okay? You got 20 days, file it. Mr. Cross is gonna have 20 days. And at the end of that time period, we'll come back up here and we'll determine what has to be happened. As a matter of fact, I'll go ahead and schedule it. Can you be back to court here on April the 24th? That gives up.
I've reached out to Apple finances are,
Applered is not going to represent you. That's for indigent people.
is there an avenue I can go down because money is an
Well,
issue?
you know, you're fixed to protect a lot of money here. There's a lot of money involved. There's tens of thousands of dollars and other people shouldn't be paying your legal bills. If you'd up front, if you'd paid a few $1,000s in legal bills, you would have avoided the problem that you have.
I've never had that money. That money's never been in my
You
possession.
can borrow money. You know, you could come up with somebody, you know now that it would be a good deal to have a lawyer to get it. Okay, thank y'all very much.
Thank you, Your Honor. I'll tender it over.